The $500,000 lie. Why Medicaid can still steal your home after you die. You've been told your home is safe on Medicaid. That's the $500,000 lie. During life, yes, the house can be exempt. After you die, the Medicaid estate recovery program can come for every dollar of equity that passes through your estate. Letters show up, deadlines start, and your kids get stuck. I'll show you how recovery actually works, why Medicaid approval doesn't mean home protected, and the legal tools that keep a house out of reach. We'll map probate versus non-probate, the exemptions that stop recovery, and the paperwork that wins. Stay with me and keep your home where it belongs, your family. What Medicaid estate recovery really is. Let's clear the fog fast. Estate recovery isn't random or vindictive. It's federal policy. Since the 1990s, states have been required to pursue recovery for certain Medicaid costs from the estates of people who received long-term services and supports after age 55, like nursing home care or home and community-based services, plus related hospital and prescription drugs. In 2025, states collectively recovered hundreds of millions of dollars through MERP programs, money most families never expected to lose because they only learned eligibility rules, not recovery rules. Every state must do this, but how they do it varies. That variation is where families get blindsided. Here's the mismatch. Eligibility rules protect the home during life. Recovery rules look at the estate after death. Two different scorecards. You can be approved, keep the home as an exempt asset, and still face a recovery claim later. Exempt now is not protected forever. What does recovery target? In many states, it targets the probate estate, the stuff that passes under a will and goes through court. Think of recovery like any creditor in probate. If your home goes through probate, it's an easy target. If it bypasses probate, the state's path can be limited, especially in probate-only states. But some states use an expanded estate definition that can reach certain non-probate transfers. That's why you confirm your state's rules before you pick a tool. You'll hear two terms, liens and recovery claims. Liens during life are rare in these cases and heavily protected if a spouse or qualifying child lives in the home. Most families see the post-death recovery claim. That timing creates planning windows before Medicaid, during Medicaid, and after death, but before probate closes. Strategy lives in those windows. There are hard limits that help. The state can't recover more than Medicaid actually paid for covered services after age 55. They also can't recover while certain protections exist. A surviving spouse is living, a child under 21 exists, or a child of any age who is blind or disabled survives. But here's the catch. These are usually deferrals, not pardons. When that status ends, recovery can resume if assets hit probate. So what exactly counts as your estate? Default is the probate estate. Assets titled in your name alone with no beneficiary or non-probate transfer setup. Wills go through probate. By contrast, beneficiary designations, payable on death (POD), and transfer on death (TOD) registrations and certain deed forms can bypass probate. In several states, enhanced life estate deeds, often called ladybird deeds, or TOD deeds move real estate directly to beneficiaries at death, outside probate. In probate-only systems, that move can change everything. In expanded estate states, you need to be more careful. Now, why families lose homes? A personal representative opens probate to transfer the house under a will. The recovery unit sends notice. Deadlines start. If no exemption or hardship is asserted on time, or paperwork is weak, the claim attaches. To sell, the estate pays the claim from net proceeds after allowable expenses. If heirs hold the property, the claim can still be satisfied later from a sale. The equity becomes the recovery source. Here's the good news. You can reduce or block claims legally. First, route the home outside probate in probate-only states. using a properly drafted and recorded ladybird deed where recognized or a statutory TOD deed with primary and contingent beneficiaries. Second, use exemptions and hardship processes when they apply. Surviving spouse or qualifying child defers recovery. Documented caregiver child or sibling occupancy can block it in some states. Hardship waivers can reduce or eliminate a claim when payment would cause severe financial harm under state criteria. Third, document everything. Funeral bills, necessary property costs, and other allowed expenses reduce the net estate before recovery is paid. Clean records matter. 2 big pitfalls. 1. Assuming Medicaid said the house is exempt means we're safe. Eligibility is today. Recovery is tomorrow. Ask, how will the home transfer? Through probate or outside it? If the answer is probate, fix it while capacity exists. 2. DIY deeds. One wrong phrase can turn an enhanced life estate into a traditional life estate, give up control, or trigger penalties. Use local elder law counsel, who knows state-specific language and recording requirements. Let me give you a quick micro story. A family relied on moms while leaving the house to 3 kids. Probate opened. A recovery notice arrived for 2 years of nursing facility and related costs. They scrambled for hardship and missed the deadline. The estate sold the home, paid allowed expenses, and the state recovered the rest. Same house, same facts. If they had recorded the right non-probate deed with alternates, the property likely wouldn't have touched probate in their state, and recovery wouldn't have had a door to walk through. If you remember nothing else, recovery is mandatory for long-term care costs after 55. Most families face it through probate, and your best defense is to route assets outside probate where allowed, claim exemptions on time with proof, and keep meticulous records. Once you think in those terms, the trap loses its spring. The trapdoor, probate versus non-probate assets. Now here's where most people mess up, assuming probate is automatic or harmless. Probate is the court conveyor belt that moves assets titled in the decedent's name alone. If your home is in your name with only a will, it almost certainly rides that belt. And once probate opens, the Medicaid recovery unit has a clear lane to file a claim like any creditor. If the house hits probate, it's exposed. If it never touches probate, in many probate-only states, recovery has nowhere to land. So what's non-probate? Assets that transfer by contract or by operation of law. Think beneficiary designations, payable on death, POD, on bank accounts, transfer on death, TOD, on brokerage, and in many states, TOD deeds or enhanced life estate, ladybird, deeds for real estate. Those skip the court conveyor belt and pass directly to the named beneficiaries at death. That one routing choice can decide whether your home is reachable or invisible to a probate-only recovery system. Let me draw a clean line you can use. A will does not avoid probate. It instructs probate. If your plan ends with the will leaves the house to my kids, you've kept the trapdoor wide open. Beneficiary-based transfers bypass probate. Life insurance with beneficiaries, non-probate. Bank account with POD, non-probate. Brokerage with TOD, non-probate. In several states, a properly drafted and recorded ladybird deed or statutory TOD deed can do the same for your home. The mechanism is different, but the effect is the same. The house jumps off the conveyor belt. Here's the shortcut nobody teaches early enough. Map every asset's path on death. Next to each one, write probate or non-probate and how it moves will POD, TOD, deed, trust, or joint with rights of survivorship where appropriate. Anywhere you wrote will assume probate, then fix it with a recognized non-probate route your state allows. For the home, that often means a ladybird deed in states that recognize enhanced life estates or a statutory TOD deed recorded before death. Always name primary and contingent beneficiaries so one predeceased person doesn't bounce the asset back into probate. 2 big cautions. First, state differences. Some states use an expanded estate definition that can reach certain non-probate transfers for recovery, like traditional life estates, or, in some places, assets in revocable trusts. In probate-only states, routing outside probate often blocks recovery. In expanded estate states, you may need different tools or timing. Second, joint ownership. Adding a child as a co-owner can be a present gift, trigger the 5-year look-back, and expose your home to your child's creditors or divorce. It can also complicate taxes. Right tool, right timing, right title form. Pros and cons quickly. Todd deeds. Simple, revocable, must be recorded before death. And they bypass probate if beneficiaries survive you. The risk is brittle design. If you forget alternates or get the form wrong, title can fall into probate anyway. Ladybird deeds, where recognized, you keep full control during life. Sell, refinance, change beneficiaries, and the transfer completes at death, which typically avoids the look-back and probate. But precise drafting matters. A sloppy clause can turn an enhanced life estate into a traditional one that gives up control. Use local elder law counsel. Revocable living trusts, great for broader planning and multi-state property, but in some expanded estate states, recovery can still reach them. They're administration tools, not universal MERP shields. Let's make this practical with a quick when-you-can-do tonight. Create a 1-page asset path map. List your home, bank accounts, brokerage, retirement, life insurance, and vehicles. Note how each transfers now. Anywhere you see, will, circle it. That's a probate trigger. Then, for each circled item, choose a state recognized. Non-probate route, POD/TOD for accounts, beneficiary updates for policies and retirement, and the proper deed tool for the home. Record deeds before death. Verify institutions actually updated beneficiaries. Get confirmations, not promises. Now, a micro story with a clean payoff. One family had a will leaving the house to 3 kids. Probate opened. The recovery letter arrived. The clock started. They missed the hardship window and sold the home, paying the claim from net proceeds after allowed expenses. Another family, same state, same house value, recorded a ladybird deed with alternates. At death, the property passed outside probate by operation of law. The recovery unit looked for probate assets. There weren't any. Claim closed. Once you nail probate versus non-probate, everything else clicks. You'll stop relying on a will and start routing by contract. You'll add alternates so one death doesn't collapse a plan. You'll avoid risky co-ownership and use state-specific deed language so you don't create a penalty or surrender control by accident. And you'll confirm your state's recovery scope before you lean on any tool. Before we move on, remember the 2 pivot questions that protect most homes. Does this asset touch probate? And does my state recover only from probate or from an expanded estate? If the house touches probate in a probate-only system, it's an easy target. Move it off that belt. If your state uses an expanded estate, get counsel to pick the right shield and timing. That clarity turns a complicated maze into a simple map. And it closes the trapdoor most families never see. The primary residence rules, safe now, vulnerable later. This is the spot where good families get blindsided. During life, the home is usually excluded for long-term care Medicaid, but that shield often vanishes at death. Eligibility rules and estate recovery rules aren't the same playbook. You qualify today, recovery may target tomorrow. Let's get precise so you can use the protection that exists now and prevent the post-death hit later. Why is the house safe during life? For long-term care Medicaid, a primary residence is generally excluded if you state an intent to return, even if that return is unlikely. If a spouse lives there, it's exempt. Many states also use a home equity cap that sits within the federal range set for each year. Stay under that cap, and the house typically won't block eligibility. That's why caseworkers say, don't sell the home. Converting exempt housing into cash can create countable assets and cause problems. But here's the catch most people miss. The lifetime exemption isn't a post-death shield. Federal law requires states to pursue recovery for long-term services and supports paid after age 55, plus related hospital and prescription drugs tied to that care, subject to protections and state procedures. During life, the program prioritizes housing stability. After death, the estate system seeks reimbursement. Same house, new rulebook. So, who blocks recovery after death? There are mandatory deferrals. If you leave a surviving spouse, the state can't recover while they're alive. If you have a child under 21 or a child of any age who is blind or disabled, recovery is paused while that status exists. Paused is the key word. When the spouse passes or a minor turns 21, recovery can resume if the home then heads into probate. Treat these protections as time you can use, not permanent pardons. Two more powerful exceptions exist in many states: the caregiver child and the sibling occupancy rules. Caregiver child usually requires an adult child to have lived in the home and provided care for at least 2 years that delayed institutionalization. Sibling occupancy often requires a sibling with an equity interest who lived there at least 1 year before institutionalization and continues to live there. Both can stop recovery outright, but the burden of proof is real. Physician statements confirming delay of placement, detailed care logs, residency evidence, tax returns, driver's license, and ownership records. You can't recreate 2 years of logs over a weekend. Start early. Let's translate all that into a usable checklist you can run with family in 10 minutes. Spouse at home, recovery is deferred. Use that window to move title outside probate with a recognized deed or plan in your state. Minor child or blind/disabled child. Recovery is paused. Document the status now and still fix the transfer path. Caregiver child, build the file. 2 years of care logs, physician letter that home care delayed placement, and residency proof. Sibling with equity and occupancy, prove co-ownership, 1 year pre-institutionalization residency, and continued occupancy. Now, where people stumble, they rely on a will. Remember, a will routes probate. If the plan ends with the will leaves the house to the kids, you've kept the door open for recovery. In states that recognize enhanced life estate, Lady Bird, deeds, the owner keeps full control during life, and the transfer completes at death, typically avoiding probate, and often avoiding look-back issues because there's no present gift. In states with transfer on death, TOD, deeds for real estate, recording a valid TOD with primary and contingent beneficiaries can pass the home outside probate at death. State language, recording rules, and timing matter. Get them right. Common pitfalls to avoid. Adding a child to the deed today. That's a present gift in many states, can trigger the 5-year look-back and exposes the home to the child's creditors or divorce. Wrong tool. Using a traditional life estate by mistake. It often surrenders control and can trigger penalties if created inside the look-back. If your state recognizes enhanced life estates, precise drafting prevents this. Forgetting alternates on TOD deeds. If a named beneficiary dies, first without contingents, title can fall back into probate and reopen recovery risk. Ignoring the spouse moves scenario. If the spouse later sells, proceeds become countable. Deeds protect the path at death, not cash created during life. Let me give you a quick micro story. A daughter called after a claim letter arrived. Mom's home was exempt. How can they take it? Mom qualified with intent to return, but the deed stayed standard, and a will left the house to 3 kids. Probate opened. The state filed a claim for facility and related costs. The family chased hardship they didn't meet and missed deadlines. If they'd recorded the right deed with alternates while mom had capacity, the property likely wouldn't have touched probate in their state. Same facts, different path. Quick when you can do this week, pull the deed and confirm title. Then write one sentence. At death, this home transfers by probate or non-probate. If it says probate, schedule a consult with a local elder law attorney and ask one precise question. Which deed or tool keeps this home out of probate here without triggering the LOBAC? Next, assemble proof for any exemption you might claim: marriage certificate, birth certificates, SSA disability determinations, care logs, physician letters, residency documents, and store them in your estate binder. If you remember nothing else from this pillar, safe now doesn't mean safe later. Eligibility shields the home during life. Recovery targets the estate after death. Use deferrals as planning windows, document exemptions thoroughly, and route the home outside probate with a state-recognized tool drafted correctly. That's how you turn a temporary shield into a lasting result. The big shields, exemptions that stop recovery. Exemptions are your legal force field. They don't change eligibility. They stop or delay recovery after death when you use them correctly and on time. The win comes from two moves. Claim the right shield with clean proof, then use that window to reroute the home outside probate, so the claim has nowhere to land later. Start with the clearest shield: a surviving spouse. Federal rules defer recovery while a spouse is alive. That's powerful, but it's a pause, not a pardon. Translation: while the spouse is living, switch the home's path off probate with your state's tool. An enhanced life estate, Ladybird, deed where recognized, or a statutory transfer on death deed, recorded before death. Don't wait for the second funeral. And a will. By then, probate reopens the door. Next shield: a minor child or a child of any age who is blind or disabled. Recovery is paused while that status exists. Again, this buys time. Document the basis now. Birth certificate for a minor, Social Security disability award or physician certification for a disabled adult child. Keep copies in the estate binder so the personal representative can respond fast when the recovery notice lands. And still fix the title path while you have capacity and options. Now, the two big exemptions that block recovery outright in many states when you can prove them: caregiver child and sibling occupancy. They're state-specific, but the evidence pattern is consistent. Caregiver child typically requires proof that the adult child lived in the home for at least 2 years immediately before institutionalization, and their care delayed the parent's facility placement. What convinces reviewers? A physician letter stating the care prevented or delayed nursing home admission, contemporaneous care logs with dates, hours, and tasks, residency proof, tax returns, driver's license, voter registration, and any in-home service notes. The mistake most families make is trying to backfill documentation after death. Start the paper trail now. Even a simple calendar plus a signed personal care agreement at fair market rates shows credible structure. Sibling occupancy usually requires that a sibling had an equity interest in the home, lived there at least 1 year before institutionalization, and continues to live there after death. You'll need the deed showing co-ownership, residency, records for timelines, and proof of ongoing occupancy. Don't create equity casually inside the 5-year LOBAC. That can be a penalized gift. If you think a sibling exemption could apply, talk to local counsel before changing title. Let's make the process executable. When a notice of intent to recover arrives, the clock starts, often 30 to 60 days. Miss it, and you turn a winnable case into a bill. Build a ready-to-file packet now so you can submit in days, not weeks. Binder checklist. Cover letter stating the exemption you're claiming and the statutory basis. Your attorney can add citations. Identity and relationship documents. Marriage certificate, birth certificates, SSA disability award. residency and occupancy proof, tax returns, leases, utility bills, driver's license, voter registration. Physician evidence, a letter describing how care delayed placement for caregiver child, or confirming disability status. Care documentation, logs, calendar entries, payment records tied to a care agreement. Property records, deed, legal description, homestead filings if applicable. Here's the thing most people miss. You can combine shields with math. Even if the exemption doesn't fully bar recovery, you can still reduce the net with allowable deductions: funeral costs, estate administration fees, property insurance, taxes, utilities, and essential repairs that preserve value. Lead with the exemption. Then attach a clean expense ledger with receipts. It's not either slash or, it's both slash and. 2 quick micro stories to show payoff. First, caregiver child done, right? A son lived with his mother for 28 months, logged care daily, and had a physician note that home care delayed admission. After death, the notice arrived. They filed within 30 days with the full packet. Claim closed under caregiver exemption. Second, sibling occupancy with proof. A sister co-owned the home for years, stayed through the year before institutionalization, and remained after death. They filed deed, tax records, and a timeline anchored to admission date. Claim closed. In both cases, timing and paperwork won the day. Common mistakes to avoid: treating spouse alive as the finish line. It's the runway. Use it to move the deed outside probate now. Filing a bare-bones letter. Exemptions are evidence-driven. Assume you're being audited. Show, don't tell. Relying on a will for protection. Wills route probate. Exemptions and deed tools change outcomes. Missing alternates on TOD or ladybird deeds. One predeceased beneficiary can bounce title back into probate and reopen recovery. Quick wins you can do this week. If there's a surviving spouse, schedule a deed review and record the right non-probate transfer with contingents. If a disabled adult child exists, add the SSA decision and a recent physician note to your binder. If a child caregiver is involved, formalize a care agreement at fair rates and start logs today. Ask the physician to note that care is delaying placement. If a sibling lives in the home and already has equity, pull the deed and line up residency proofs. If they don't have equity, don't transfer inside the look-back without counsel. Bottom line, exemptions are powerful, but only when you prove them on time and use the breathing room to reroute title. Claim the shield when the deadline and record the deed that keeps the home off the probate conveyor belt. That's how you turn temporary protection into a permanent result. Hardship waivers, when you can't pay without losing the house. If exemptions don't fit, there's still a last lifeline: the hardship waiver. It's not automatic, it's not guaranteed, and it's not a planning strategy you bank on upfront. But when paying the claim would force an heir to sell the home or push a household below basic living standards, states must offer a process to reduce or waive recovery. The key word is process. Deadlines are short, often 30 to 60 days from the notice, and approvals are evidence-driven. If you can't prove it, it doesn't count. Why does hardship exist? Recovery is federally required for long-term services and supports after age 55, but states are also required to avoid outcomes that are unduly harsh or cost-ineffective. So they set narrow lanes for relief. The lanes vary, but you'll see patterns. Financial hardship based on income and expenses, a modest homestead occupied by a low-income heir, and in some states, property that's an heir's primary income source, like a family farm or small business on the homestead. Your state's manual defines the criteria, forms, and proofs. Pull it the day the letter arrives. Here's the mistake families make: waiting to open the mail, then writing a heartfelt letter with no numbers. Hardship is math plus documentation. You need to show the reviewer, in their format, that recovery would cause severe financial harm under their rules. Treat it like an audit. Build a packet that answers every question before it's asked. Then file before the clock runs out. Let me show you exactly how to assemble a winning file. Start with identity and standing. Include the death certificate, the notice of intent to recover, letters of administration, or other proof you represent the estate, and your relationship to the decedent. If the property is your primary residence, add occupancy proof. Right here, driver's license, voter registration, tax returns with the address. Next, the financial core. For every adult in the household, include 2 years of tax returns, the most recent pay stubs, and 3 to 6 months of bank statements. Add a written monthly budget. Housing, utilities, food, transportation, insurance, healthcare, and any debt payments. Tie the numbers to statements. Then print your state's poverty or median income table and mark your household size. The goal is simple. Demonstrate with third-party documents that paying the claim would push the household below the threshold or cause loss of shelter. Now, prove the property picture. Include the deed, legal description, property tax bill, and homeowner's insurance declarations. Order a broker price opinion or appraisal. Don't rely on a stale tax assessment. Attach mortgage payoff or lien statements. If condition matters, add photos and repair estimates to show why sale proceeds would be lower than casual estimates suggest. If the property is income producing, include leases, rent rolls, farm schedules, or business returns. Then reduce the claim with allowed deductions. List funeral and burial costs, estate administration expenses, and necessary property preservation, insurance, taxes, utilities, lawn care, pest control, and essential repairs. Create a simple ledger with dates, amounts, categories, payment method, and an exhibit number. Put each receipt behind its entry. You're shrinking the net estate before the claim is applied. If you might qualify under a modest homestead or special use rule, add context. Write a brief factual statement connecting your facts to the regulation. The home is your primary residence. Your income sits below the listed threshold, and recovery would cause loss of shelter or elimination of the family's income base. Keep it tight and reference exhibits by number. Package it with a clean cover letter. Identify the claim. Cite your state's hardship rule by section if possible. State the grounds you meet and make a clear ask, waiver, reduction, or if neither is granted, a payment plan that preserves occupancy. Include a numbered exhibit list. Submit by certified mail or via the state's portal. Keep a full copy and calendar follow UPS at 14 and 30 days. If the agency asks for more info, respond within 5 business days. Speed signals seriousness. 2 quick micro stories. First, denied then approved. An heir sent a 1-page plea, "We can't afford this." Denied. They appealed with pay stubs, tax returns, a budget, a broker price opinion, funeral receipts, and 6 months of utilities. They showed recovery would push the household below the threshold and risk eviction. Waiver granted. Same facts, different paperwork. Second, partial relief. A family farm qualified as the heir's primary income source. They filed leases, Schedule F returns, insurance, and maintenance logs. The state reduced the claim to a small settlement payable over time. No forced sale. Common mistakes to avoid: missing the deadline, sending estimates instead of receipts, ignoring valuation, and failing to tie facts to the rule. Another big one: relying on hardship instead of restructuring title. Hardship is a safety valve, not a plan. Use it if you must, but your best move is still to keep the home off the probate conveyor belt. Quick wins you can do this week: download your state's hardship form, build a template packet with blank income and expense worksheets, draft a cover letter skeleton, and add a contact sheet for the recovery unit. Then start an expense ledger now: funeral, insurance, taxes, utilities, and essential repairs, so deductions are ready. If a letter arrives, you can file in days, not weeks. Bottom line: hardship works when it's timely, documented, and mapped to the rule. File on time, prove the math, and ask clearly for the relief the statute allows. Planning before crisis, legal tools that work. The best protection happens before anyone needs care. When you plan early, you choose tools that fit your state, your taxes, and your timeline, and you avoid last-minute moves that backfire. Let's walk through the core options, where they shine, and the trade-offs you need to respect so you don't trigger the look back or invite recovery later. Start with the heavyweight, an irrevocable Medicaid Asset Protection Trust, often called a MAPT. Why use it? Because when it's drafted correctly and funded more than 5 years before you apply for long-term care Medicaid, the assets in it are typically off the eligibility balance sheet and, critically, outside the estate recovery reach in many states. You can usually keep the right to live in the home via occupancy rights, have the trust pay taxes and upkeep, and appoint a trusted child or professional as trustee. Done right, many MAPs are structured as grantor trusts, preserving a step-up in basis at death, so heirs aren't punished with avoidable capital gains. The trade-offs are real. A MAPT is irrevocable, so you don't pull principal back for personal spending. And funding it starts the 5-year look-back. If you're inside that window when you apply, you'll face a penalty period. That's why MAPs are for true pre-planning. Think 5+ years out, not 5 months out. If you're healthy enough and the horizon looks long, a MAPT can protect the home and other non-retirement assets while keeping daily controls separate from ownership. Now, the deed tools. In states that recognize enhanced life estate deeds, often called ladybird deeds, the owner keeps full control during life. Live there, sell, refinance, even change beneficiaries. The transfer completes at death, so it typically avoids the 5-year look-back, no present gift, and bypasses probate, which often blocks recovery in probate-only states. Precision matters. One wrong phrase can turn an enhanced life estate into a traditional life estate that surrenders control and may trigger penalties. Use local elder law counsel who knows the exact language title underwriters expect. If your state offers transfer on death (TOD) deeds for real estate, they can accomplish the same probate avoidance goal. TOD deeds are revocable, must be recorded before death, and pass the property directly to named beneficiaries. The landmines, strict statutory forms, recording requirements, and the need to list contingent beneficiaries so a predeceased primary doesn't bounce the home into probate. Also, in some expanded estate states, certain non-probate transfers may still be within recovery reach. Verify your state's scope before relying on TOD alone. Where do revocable living trusts fit? They're excellent for incapacity planning, privacy, and avoiding multi-state probate when properly funded. But in some states that use an expanded estate definition, assets in a revocable trust can still be reachable for recovery. So treat a revocable trust as an administration tool, not a guaranteed MERP shield, unless your state confirms otherwise. Here's a simple decision path you can use with your attorney. Are you likely 5 or more years from needing long-term care? Consider a MAPT for the home and other non-retirement assets, MAP tax treatment, trustee choice, and funding timing. Inside 5 years, but capacity is intact and your state recognizes ladybird deeds. Use a ladybird deed for the home and pair it with POD/TOD on accounts to keep assets off the probate conveyor belt. If your state uses TOD deeds, instead, confirm statutory language, add alternates, and record now. If you own property in multiple states, consider a revocable trust for probate control. Then fund the trust or beneficiaries with state-specific deeds. Confirm recovery reach for each jurisdiction. 2 critical cautions. First, DIY documents. Templates that aren't state-specific cause the most expensive mistakes I see. Accidentally creating a traditional life estate, failing to reserve full powers, or missing a recording requirement that kills the protection. Second, sale risk. Deed tools protect the title path at death. They don't protect sale proceeds during life. If downsizing is likely, timing is everything. Without a seasoned MAPT seasoned beyond 5 years, cash from a sale becomes countable and can derail eligibility. Let's translate this into a clean, 30-minute consult checklist you can bring to local counsel. Bring the current deed, mortgage info, property tax bill, homeowner's insurance declarations, a beneficiary list for all accounts, and a one-page asset path map that labels each item probate or non-probate today. Ask exactly 3 questions. Which deed tool keeps my home out of probate here without triggering the look back? If we're 5+ years out, how would a MERP affect taxes, basis, and control? How do we coordinate POD/TOD on every account so one stray asset doesn't force probate? Quick wins this week. Pull and read your recorded deed. Confirm who's on title and how. Create your asset path map. And circle anything that still says will. If you're in a Lady Bird or TOD state, schedule a deed review and record the correct instrument with contingents. Then sweep beneficiaries, POD on bank accounts, TOD on brokerage, and, where allowed, vehicles, and confirm institutions actually updated their records. Finally, write down your likely timeline to care, years, not months, and decide whether a MERP conversation makes sense now or next review. Plan early if you can, but even late, the right tool, matched to your state and your timing, keeps the home off the probate conveyor belt. And out of reach. In crisis moves, what you can still do. If you're already in care or approval just landed, don't freeze. You still have moves that lower recovery risk and protect eligibility. The key is acting fast, clean, and in the right order, without triggering the 5-year look back or forcing probate later. Start by asking one question. If the owner died today, what forces probate? If the answer is the house under a standard deed, fix the path while capacity exists. In states that recognize enhanced life estate, Lady Bird deeds, record one with primary and contingent beneficiaries. If your state uses transfer on death deeds for real estate, record a valid TOD with alternates now. Both routes bypass probate at death, which often blocks recovery in probate-only states. Remember, these deeds protect the transfer at death, not sale proceeds during life. Next, stabilize eligibility without gifts. Convert countable cash into permissible, necessity-based expenses that also preserve the property. Pay current property taxes and homeowners insurance. Handle essential repairs that prevent damage, roof leaks, HVAC safety, and keep utilities on to avoid burst pipes or code issues. Replace an unreliable vehicle with one reliable car if your state allows it as exempt. Prepay allowable funeral/burial arrangements as your state permits. Keep every receipt. Those same records can reduce a future claim as allowed estate and preservation costs. If family is providing real care, formalize it now. Create a written personal care agreement at fair market rates while the elder has capacity, log hours and tasks, and pay by check or ACH, not cash. This turns vague help into legitimate spend that avoids the look-back gift presumption, may help eligibility math, and in some states can reduce a recovery claim as verified caregiving. Do not backdate agreements. Paper trails win. Improvisation loses. Route non-home assets off the probate conveyor belt so a stray account doesn't reopen the door you just closed. Add payable on death to bank accounts, transfer on death to brokerage and, where allowed, vehicles, and update beneficiaries for life insurance and retirement accounts. Call each institution to confirm updates are recorded, get written confirmations or screenshots. In probate-only recovery states, this sweep matters as much as the deed. About the 5-year look-back, stop gifts immediately. No $1 transfers, no adding kids to title, no helping with cash without fair value documentation. If questionable transfers already happened, pull 60 months of statements, list dates, amounts, and recipients, and work with counsel to cure what you can. Returned funds can reduce or eliminate penalty periods. Where return isn't possible, document any fair value exchanges. home repairs, caregiving, rent, with invoices, contracts, and proof of payment. Without proof, Medicaid presumes a gift. Capacity determines your speed and options. If capacity is intact, verify the power of attorney explicitly authorizes beneficiary updates, TOD or Lady Bird deeds where legal, and handling estate recovery correspondence. Many generic POAs lack these powers. Update now. If capacity is gone, you may need guardianship or court approval. That's slower, so prioritize essentials, securing the home, preserving insurance, and preventing probate triggers. Here's a 72-hour triage that works. Day 1. Secure the house, locks, mail forwarding, verify insurance is active and correct, vacancy rules matter, set property tax autopay, and take date stamped. Condition photos, pull the recorded deed, and schedule a consult with local elder law counsel. Start a binder, Medicaid notices, approval letters, the deed, tax and insurance statements, utility accounts, maintenance log, and funeral arrangements. Day 2. Record the Lady Bird or TOD deed if your state allows and capacity permits. Add pod/TOD to accounts. Update life insurance and retirement beneficiaries. Request 5 years of bank statements if LUBAC issues exist. Day 3. Formalize caregiving agreements, start care logs, order a broker price opinion for eventual valuation, and create an expense ledger for insurances, taxes, utilities, lawn/pest, and essential repairs with receipt placeholders. 2 timing traps to avoid. First, December surprises. A late year transfer or sale can push income or valuation into a bad calendar year. If you're near any threshold, eligibility, taxes, or future hardship criteria, consider splitting actions across January when legal. Second, beneficiary gaps. If a named beneficiary predeceases the owner and no contingent is listed, that asset can fall into probate. Update contingents now on deeds, accounts, and policies. If a recovery notice arrives, don't panic. Calendar the response deadline immediately. Request an itemized statement of Medicaid paid amounts by date and category. Pull your binder and start 2 tracks in parallel. Exemptions: spouse, minor or disabled child, caregiver child, sibling occupancy, with proof, and hardship math with exhibits if needed. Submit on time with delivery confirmation. Silence kills good cases. Married couples should use spousal protections and coordinate title. The community spouse can often retain resources under your state's rules. Don't impoverish the healthy spouse or liquidate the home without a plan. Convert excess countable assets into exempt forms the spouse can keep, and route title outside probate with the right deed tool plus alternates. If downsizing is likely, map the timing carefully. Sale proceeds are countable unless protected by a seasoned trust. Quick don'ts to finish. Don't rely on a will, it routes probate. Don't add children to the deed. That can trigger look-back penalties and creditor exposure. Don't miss certified letters. Set mail monitoring and alerts. Don't assume a revocable trust is a shield in your state. Confirm recovery, reach first. You're late, not lost. Route the home off probate, where allowed. Preserve eligibility with lawful conversions, formalize caregiving, sweep beneficiaries, and build that binder. Speed plus clean paperwork turns crisis into control. The money math, claims, equity, and what survives. Let's make the numbers do the talking, because once you see the ledger, smart choices feel obvious. Medicaid can't recover more than 2 limits: what the program actually paid for covered long-term services and supports after age 55, plus related hospital and prescription drugs tied to that care, and what it can legally reach, often the probate estate in probate-only states. Your job is to shrink that reachable pot, or better yet, keep the house off the probate belt altogether, so its math never enters the equation. Start with a simple framework: paid versus pot. On one side, request the itemized Medicaid paid ledger by date and category. On the other, calculate the net probate estate after allowed deductions. Recovery equals the lesser of the paid ledger or the net pot the claim can touch. If either side goes down, the recoverable amount goes down. Now, what reduces the pot? Allowed, well-documented deductions and priority costs. Think reasonable funeral and burial expenses, court filing and publication fees, personal representative and attorney fees, property insurance, property taxes, essential utilities, lawn/pest for preservation, and necessary repairs to prevent damage or close a sale, roof patches, leak remediation, safety fixes. Key rule: if you can't prove it with receipts, statements, and a clean ledger, it rarely counts. Build that ledger early, not in panic. Let's run crisp examples. Example A. House with mortgage and deductions. Clear calculation. Mom's home sells for $500,000. Mortgage payoff: $110,000 realtor commission plus closing costs, $30,000 net after mortgage and sale costs, $360,000 deductions from estate, allowed funeral, $12,000 estate administration, $9,000 insurance, taxes, utilities, $4,500 essential repairs, $3,500 net estate after deductions, $331,000 Medicaid paid ledger, $240,000 recoverable amount equals lesser of $331,000 net estate or $240,000 paid equals $240,000 heirs receive, $91,000. Example B. Same house, higher paid ledger, lesser of, still controls, same net estate after deductions, $331,000 Medicaid paid ledger, $168,000 recoverable amount equals lesser of $331,000 or $168,000 equals $168,000 heirs receive. $163,000 mortgages matter because they're senior liens. If the house sells for $500,000 and the payoff is $250,000, you don't have a $500,000 recovery. Base, you have proceeds after that debt and closing costs. Always attach the payoff statement and the final closing disclosure. Clean documentation tightens the math and prevents inflated assumptions. Valuation is another lever. Don't rely on a stale tax assessment. Order a broker price opinion or appraisal pegged to date of death. If condition drags, value, document, as is photos and estimates. Lower fair market value when accurate yields lower net estate after ordinary costs. The goal isn't to deflate, it's to reflect reality with third-party evidence. What about liens versus claims? In most age 5+ long-term care cases, families don't see a pre-death lien on a protected homestead. They see a post-death probate claim. That order matters because mortgages and sale costs come off first, administration and necessary preservation next, and the recovery claim sits in the stack like an ordinary creditor with statutory priority. You're not guessing what gets paid before what the process dictates it. Use that to your advantage with receipts and timelines. Now, the hidden superpower: path beats math. If you used a properly drafted and recorded enhanced life estate, Lady Bird, deed in a recognizing state, or a valid transfer on death deed, recorded before death in a probate-only state, the house often bypasses probate entirely. In that case, the home isn't in the reachable pot, so its equity isn't part of the recovery calculation at all. The number for the house drops to zero because there's no probate value to touch. That's why routing around probate is more than legal theory. It rewrites the ledger. 2 edge factors can also help. First, cost-effectiveness thresholds. Some states won't pursue tiny net estates or minimal claims because collection costs exceed recovery. Don't count on that for a high-equity home, but if the estate is small or underwater after debts, ask whether your state's manual lists low-value exceptions. Second, hardship waivers modify the claim based on documented impact. They don't change what Medicaid paid. They reduce or waive what's recoverable due to your numbers. When granted, they lower the claim column, not the valuation column. Here's your quick worksheet. Medicaid paid ledger. Request itemized by date, category, and post-5/5 total. Estate inventory. List probate assets only. Identify non-probate to avoid mixing apples and oranges. Valuation. Attach a BPO or appraisal. Include mortgage payoff and closing disclosures. Deductions ledger. Funeral, admin, insurance, taxes, utilities, preservation repairs, each with receipts and bank proof. Net estate after deductions, the pot the claim can actually reach. Compare. Recovery equals the lesser of net pot or paid ledger. Common mistakes that cost real dollars, missing receipts or paying cash. No paper equals no deduction. Over-optimistic market value without third-party support. Forgetting admin and preservation expenses, the estate already paid. Mixing non-probate assets into the probate pot, inflating the target, ignoring mortgage payoff timing, and relying on estimates instead of final statements. Bottom line, do the math, document the math. And best of all, change the math with the right title path. Keep the house out of probate where allowed, and it drops out of the recoverable pool. If probate is unavoidable, tighten the net with accurate valuation and every allowed deduction. The numbers are neutral. If you feed them proof, they'll often leave more for your family than fear suggests. The sneaky mistakes that trigger recovery. Let's turn this into traps you can actually avoid. These are the quiet moves that hand your home to recovery on a silver platter, plus the clean fixes that shut the door. Mistake 1, relying on a will. A will instructs probate. It doesn't avoid it. When the house rides the probate conveyor belt, the recovery claim has a lane. Fix, use a state-recognized enhanced life estate, Ladybird, deed where available or a statutory transfer on death, TOD, deed recorded before death with primary and contingent beneficiaries. Mistake 2, adding a child to the deed to be safe. That's often a present gift, can trigger the 5-year look-back, and exposes your home to your child's creditors, divorce, and lawsuits. It can also mess up step-up in basis at death. Fix, use beneficiary-style transfers that complete at death, Ladybird or TOD deeds, so there's no present gift and no creditor exposure from your child during life. Mistake 3, using a traditional life estate by accident. One wrong phrase can surrender control and create a penalized gift if made inside the look-back. Fix, if your state recognizes enhanced life estates, get precise language that reserves full powers to sell, mortgage, and change beneficiaries. If not, confirm whether TOD deeds or trust-based options fit your state. Mistake 4, forgetting alternates. A single predeceased beneficiary can bounce the house or accounts back into probate. Fix, always list contingent beneficiaries on deeds, POD/TOD registrations, life insurance, and retirement accounts, and review them annually. Mistake 5, leaving a stray asset that forces probate. You might route the home perfectly, but leave a small bank account or vehicle titled only in the decedent's name that can open probate and invite recovery. Fix, add POD to bank accounts, TOD to brokerage, and where allowed, vehicles, and verify updates were recorded by the institutions, not just requested. Mistake 6, treating spouse/disabled child protections as permanent. Those are deferrals. When the spouse dies or the status ends, recovery can resume if the home then hits probate. Fix, use the runway to reroute title now with the correct deed and contingents, and sweep every account to POD/TOD. Mistake 7, selling during life without a plan. Deed tools protect the transfer at death, not sale proceeds. Cash from a sale is countable for eligibility and can blow up the budget. Fix, if downsizing is likely, map timing with counsel. If a seasoned irrevocable Medicaid asset protection trust exists beyond 5 years, proceeds inside it may stay protected. Otherwise, holding and transferring at death may be safer. Mistake 8, DIY deeds and forms. State quirks matter. Sloppy drafting can create a traditional life estate, omit reserved powers, or miss recording steps. Fix. Pay a local elder law attorney who knows underwriter-approved language, county recording rules, and your state's recovery scope. Mistake 9. Missing MERP deadlines. Exemptions and hardship waivers are deadline-driven, often 30 to 60 days from the notice date, not the open the envelope date. Fix. Set mail forwarding, track certified letters, and keep a pre-built exemption/hardship packet in your binder so you can file in days, not weeks. Mistake 10. No caregiving paper trail. Families try the caregiver child exemption with no logs, no physician letter, and weak residency proof. Fix. Sign a fair market personal care agreement while the elder has capacity, log hours and tasks, pay by check or ACH, and get a physician letter stating home care delayed placement. Mistake 11. Confusing liens with recovery claims. Most families won't see a pre-death lien on a protected homestead. They'll see a post-death probate claim. Fix. Focus on the path at death. Keep the house off the probate belt, then document deductions that shrink any remaining claim. Mistake 12. Ignoring valuation and deductions. Using a stale tax assessment and tossing receipts costs real money. Fix. Order a broker price opinion or appraisal at date of death. Keep every funeral administration, insurance, taxes, utilities, lawn/pest, and essential repair receipt, and build a clean ledger that ties each dollar to preservation, not upgrades. Mistake 13. Weak powers of attorney. Generic POAs often don't authorize beneficiary updates, TOD or Ladybird deeds, or MERP correspondence. Fix. Update the POA now with Medicaid-aware powers so an agent can execute the plan if capacity slips. Mistake 14. Trust assumptions. A revocable living trust avoids probate, but can still be within reach in some expanded estate states. Fix. Confirm your state's recovery scope. Use revocable trusts for administration. Use maps for 5+ year planning. Use deed tools for late planning. Mistake 15. December moves that backfire. Late year transfers or sales can push income or valuation into a bad calendar year and shrink hardship odds later. Fix. Use a Q4 checkpoint. If you're close to a threshold, split. Actions across January when legal. Quick 10-minute MERP risk audit you can do tonight. Circle the home's path, probate or non-probate. List all accounts with transfer method and contingents. Pull the POA and confirm the right powers exist. Note any missing receipts for preservation expenses. Start the ledger now. If anything says will unknown or no receipts, book a local elder law consult and fix those gaps. Small moves now prevent big losses later. Documentation that wins. Paperwork and proof. Paper beats panic. Estate recovery is a paperwork game, and the families who win aren't the loudest, they're the most organized. Your goal is simple. Build a file that proves what's exempt, shrinks what's recoverable, and answers every question before it's asked. Start with a MERP binder, physical and digital. 5 tabs: eligibility and notices, property, money, care and occupancy, and communications. Under eligibility and notices, keep the Medicaid approval, renewals, any caseworker letters, the notice of intent to recover, and a simple timeline: application date, approval date, institutionalization date, date of death, probate filing date, and claim deadline. That one-page timeline keeps everyone on pace. Under property, store the current deed, plus prior if relevant, legal description, homestead designation if applicable, mortgage payoff, property tax bills, homeowners insurance declarations, and utility accounts with start/stop confirmations. Add date-stamped photos of the home at death, contractor estimates, and actual repair invoices. Finish with a broker price opinion or appraisal tied to date of death and comps. Valuation drives math. Don't rely on a stale tax assessment. Under money, create an expense ledger and back it with receipts. Track funeral and burial costs, court fees, publication, attorney and personal representative fees, insurance, taxes, essential utilities, lawn/pest, and urgent repairs that preserved value or enabled sale. Each line should list date, category, amount, payer, method, check number, card, ACH, and an exhibit number. If you can't prove $1, assume it won't count. Under care and occupancy, assemble exemption evidence. For caregiver child, a physician letter that home care delayed placement, 2 years of care logs with dates, hours, and tasks, assigned personal care agreement at fair rates, and residency proof, driver's license, voter registration, and tax returns at the address. For sibling occupancy, deed showing equity interest, 1 year pre-institutionalization residency records, and proof they still live there. For disabled child, SSA disability award or physician certification. For spouse or minor child, marriage or birth certificates, and occupancy proofs. Under communications, keep every letter to and from the recovery unit, delivery confirmations, email read receipts, and a phone log with date, time, contact name, and summary. Add a master index of exhibits. When reviewers can follow your trail, they say yes faster. Now, request key documents early. Ask the recovery unit for an itemized accounting of Medicaid paid amounts after age 55 by date and category, nursing facility, HCBS, related hospital, and prescriptions. Errors happen. You can't dispute what you can't see. Also, download your state's hardship and exemption forms on day 1, even if you're not sure you'll use them. Deadlines are short. Forms save time. Build your response packet like an audit. Page 1, a concise cover letter stating your position. Exemptions claimed. Cite the statute if available, hardship requested, and the deductions you're applying. Include a numbered exhibit list. Add a summary table. Start with the state's claim amount. Subtract allowed expenses with exhibit references. Show net estate. Then compare to the paid ledger. Recovery equals the lesser of those numbers. You're not arguing, you're calculating. Common mistakes to avoid: missing deadlines because mail sat unopened, sending estimates instead of receipts, ignoring occupancy history, mixing improvements with preservation, upgrades rarely count, and relying on a tax assessment for value. Fix them by setting mail forwarding, creating a receipt recovery routine, call vendors for duplicates, pulling DMV/voter/tax records early, labeling expenses as safety, prevention, or required for sale, and ordering a BPO or appraisal. Power tools: a durable power of attorney that expressly authorizes beneficiary updates, TOD/Ladybird deeds where legal and MERP correspondence and appeals. A shared cloud folder for the family with read-only access for non-editors, calendar triggers at 14, 30, 45, and 60 days after notice for drafting, filing, follow-up, and appeal windows. Tight process beats good intentions. Let me show you exactly how this pays off. Family, a sent a 3-paragraph, we can't afford it note. Denied. They regrouped with a 40 exhibit packet. The date of death, BPO, funeral receipts, 5 months of insurance/taxes/utilities, an expense ledger with matches to bank statements, and a caregiver file with physician letter and logs. The reviewer reduced the estate pot with every allowed deduction, credited verified caregiving per state rules, and approved hardship on the balance. Same facts, different paperwork. Quick wins this week. Start your ledger, create columns for date, category, amount, method, and exhibit. Print placeholders for receipts. Photograph the property condition, exterior and key interiors, and file them. Request the Medicaid paid ledger in writing. Ask for a CSV or PDF itemization. Download your state's hardship and exemption forms. Pre-fill names, addresses, and decedent data. Draft a cover letter template with 3 blanks: statute site, claim number, and exhibits. Bottom line, if you can show it, you can count it. Build the binder now. Keep proofs tight and answer questions before they're asked. Organized evidence turns recovery into arithmetic, and arithmetic is winnable. Picking the right help, attorney, planner, or DIY. The right guide saves money, time, and stress. The wrong one costs you the house. Let's make this practical so you know who to call, what to ask, and what you can safely do yourself without overpaying or risking mistakes. Start with roles. An elder law attorney handles Medicaid eligibility, deed strategy, exemptions, hardship probate risk, and your state's recovery rules. An estate planning attorney focuses on wills and trusts. Some also handle Medicaid, many don't. A fiduciary financial planner coordinates cash flow, beneficiary cleanup, income timing, and tax guardrails so no move trips IRMA or bracket jumps. Your CPA validates the math, confirms deductions, reviews basis and valuation, and makes sure your packet lines up with your state's rules. In a tight budget, you can combine planner and CPA if they're fluent in both tax and retirement income. How to choose quickly. For an attorney, lead with state experience. How many MERP claims did you handle last year? Which deed tools does our county recorder and local title underwriters accept without delay? In our state, is recovery probate-only or expanded estate? What deadlines apply for exemptions and hardship, and what documents win? Can you show me a successful sample packet? For a planner, can you build a one-page asset path map listing probate versus non-probate for every account? Will you design a 12-month income calendar that keeps us under our bracket and IRMA targets while we implement title fixes? For a CPA, will you run a pro forma that compares a probate sale versus non-probate transfer, including deductions? So our numbers are audit tight, fees should be clear. Expect flat fees for deed work, beneficiary audit, and MERP response packets, hourly for complex disputes. Ask for ranges in writing. Deed plus recording, beneficiary sweep, MERP binder review, hardship filing, and follow UPS. For planning, ask for a fixed project fee covering the asset path map, beneficiary audit with contingents, and 1-year income timing that avoids bracket cliffs. If someone won't quote or hedges with jargon, move on. DIY boundaries matter. You can safely build the MERP binder and expense ledger, collect 5 years of bank statements, and create a transfer log. Add pod/TOD to bank, brokerage, and where allowed vehicles, order a broker price opinion or appraisal, gather funeral insurance, taxes, utilities, and repair receipts, download state hardship/exemption forms, and pre-fill IDs and addresses. You should not DIY, draft or record Ladybird or TOD deeds, create a traditional life estate by accident, file caregiver or sibling exemptions without physician letters, logs, and citations, cure look-back transfers, or rely on a revocable trust as a shield in an expanded estate state without legal confirmation. Use tight vetting scripts. Attorney's 7-pack. Do you regularly handle MERP and Medicaid deed planning in our county? Is our state probate-only or expanded estate? And which non-probate tools are safest here? What exact deed language do local title companies accept? What are our exemption and hardship deadlines and proof standards? Can you map a 72-hour triage? Deed, pod/TOD, POA powers binder setup? How do you coordinate with planner/CPA to avoid IRMA, bracket jumps, or tax surprises? Flat fee for deed, an MERP packet, hourly beyond, and timeline? Planner 6-pack, 1-page asset path map with contingents, verified with institutions, a 12-month income calendar that keeps us under our bracket, and IRMA caps, beneficiary audit and confirmations in writing, strategy to prevent one stray account from forcing probate, coordination plan with attorney on deed timing and CPA on deductions, fixed fee for map calendar, audit, CPA 5-pack, pro forma comparing probate sale versus non-probate transfer with deductions tied to exhibits, review of expense ledger format. So Every dollar counts. Guidance on valuation evidence, BPO versus. Appraisal for date of death. Checklist for hardship math tied to state thresholds. Timeline for quick turn on claim responses and appeals. Red flags. AWIL protects the house. Just add your kid to the deed. This template works in every state. We'll send a quick letter. You don't need a CPA. Any firm that won't show underwriter-approved deed language for your county is guessing with your home. A simple 4-week workflow works. Week 1, attorney confirms recovery scope, drafts the correct deed with reserved powers and contingents, and updates POA powers beneficiaries, TOD/Ladybird deeds. MERP appeals. Week 2, planner builds the asset path map, sets POD/TOD on every account, verifies updates, and drafts a 1-year income calendar. Week 3, you assemble the binder, order a date of death BPO or appraisal or a practice run, start the expense ledger, and pull disability, marriage, or caregiver proofs. Week 4, CPA reviews the ledger and valuation, runs a pro forma for deductions and hardship math, and prepares a cover letter numbers page. On a budget, prioritize deed and beneficiary cleanup first. Those 2 moves usually handle 80% of protection in probate-only states. Then build the binder and valuation file yourself. Use the CPA for a 1-hour sanity check. One last tip, ask every pro for a written scope, deliverables timeline, and a single point of contact. Clarity beats assumptions. With the right team and clear roles, you'll route the house off the probate belt, keep deductions tight, hit deadlines, and turn a scary letter into solvable math. The 10-step Home Saver Action Plan. Clear steps beat confusion. Use this plan to lock your home's path now, shrink any future claim, and keep paperwork tight if a letter arrives. Follow these in order, and you'll feel risk dropping with each move. Step 1. Map what you own. On one page, list the home, bank accounts, brokerage, retirement, life insurance, and vehicles. Next to each, write how it transfers today. Will trust, POD, TOD, deed, or joint with survivorship. Anywhere you wrote, will circle it. That's a probate trigger and a recovery door. Step 2, identify probate risk. Ask one question. If I died tonight, would any asset force probate in my state? If yes, mark it in red. In probate-only recovery states, anything in red is MERP's front door. Your goal is to remove every red line you legally can. Step 3, decide the home's path. With local elder law counsel, pick your state-recognized tool. In Ladybird states, use an enhanced life estate deed, reserving full powers and naming primary and contingent beneficiaries. In TOD states, record the statutory TOD with alternates, confirm county recording requirements, and keep a certified copy in your binder. Step 4, clean up beneficiaries. Add POD to bank accounts and TOD to brokerage and, where allowed, vehicles. Update life insurance and retirement beneficiaries with at least one contingent. Call each institution to confirm updates are on file. Save confirmations or screenshots. Don't assume. Step 5, fix titles and strays. Close or retitle any orphan accounts that could force probate. If you use a revocable trust for administration, ensure funding matches your state's recovery scope. One stray checking account can reopen MERP's door. Don't let it. Step 6, prep exemption and hardship packets. Download your state's exemption and hardship forms. Pre-fill names, addresses, and decedent info. Add placeholders for marriage certificates, birth certificates, SSA disability awards, caregiver logs, occupancy proofs, and a budget worksheet. Put a draft cover letter on top with blanks for citations, claim number, and exhibits. Step 7, build the MERP binder. 5 tabs: eligibility and notices, property, money, care and occupancy, communications. Insert the recorded deed, mortgage payoff, tax bills, insurance declarations, utility accounts, funeral arrangements, and a blank expense ledger. Add a standing request template for the Medicaid paid ledger. Organize proof wins. Step 8. Create a crisis checklist. Your 72-hour plan if health changes or death occurs. Secure the house, update insurance status, take date-stamped photos, pull the recorded deed, verify POD/TOD, order a broker price opinion, and request the state's itemized claim ledger. Add a bold reminder. Do not open probate for the home. Call the attorney first. Step 9. Schedule professional reviews. Book a 45-minute attorney check to confirm deed language and state recovery scope. Ask a planner to build a 12-month income calendar that keeps you under bracket and IRMA thresholds while you implement title fixes. Have your CPA review your deduction ledger format and valuation plan, so every dollar counts later. Step 10. Set maintenance routines. Twice a year, reconfirm beneficiaries, deed, recording visibility, insurance coverage, and binder completeness. Refresh caregiver and occupancy documentation if applicable. Reprint your state's hardship thresholds and deadline rules. Put calendar reminders for March and September. Execution prompts you can use today. Attorney call script. We need the deed that keeps our home out of probate in state, with alternates recorded this month. Does our state recover from non-probate assets? What exact language do local title companies accept? Planner call script. Build a one-page asset path map and beneficiary audit. Identify any stray asset that forces probate. Create a 12-month income calendar that keeps us under bracket and IRMA targets while we implement fixes. CPA call script. Review our expense ledger and valuation plan. Which items reduce recovery here? And what evidence do reviewers expect? When a claim arrives, how should we present deductions and tie them to exhibits? Housekeeping wins this week. Order a broker price opinion pegged to date of death for a recent comparable case as a practice run. Learn the process. Set utilities to auto-pay and verify homeowners' insurance, including vacancy rules. Start a maintenance log. Date, task, vendor, cost, and why it preserved value. Print 3 certified copies of your recorded deed and file 1 in the binder. Myth killer that saves homes. A will is not a protection strategy. It's a set of instructions for probate. Your protection strategy is routing around probate where your state allows, claiming exemptions, fast with proof, and documenting every dollar that shrinks a claim. Microstory anchor. Family A had a will and a standard deed. Probate opened. The recovery letter arrived, and they missed the hardship deadline. The house sold. Allowed costs reduced the POD, and the state recovered the rest. Family B, same facts, had a properly recorded Ladybird deed, with alternates and POD/TOD on all accounts. The house bypassed probate. The small checking account didn't force a court file. Claim closed. Your one next step tonight. Finish step 1 and step 2. If you see will or unknown, book the deed consult and start the beneficiary sweep. Small moves now prevent big losses later. Action beats anxiety every single time. Myths that cost families their home. Myth 1, Medicaid can't touch your home. That's only true for eligibility while you're alive under the homestead exemption and intent to return rules, or when a spouse lives there. After death, federal law requires states to seek recovery for long-term services and supports paid after age 55, plus related hospital and prescription drugs. If the home goes through probate, expect a claim unless a valid exemption or hardship applies and is filed on time. Myth 2, a will protects the house. A will instructs probate. It never avoids it. Probate is the arena where estate recovery shows up. Protection comes from routing the home outside probate, state-recognized enhanced life estate, Lady Bird deeds were available or properly recorded transfer on death deeds, or from a MERP funded more than 5 years before applying, subject to your state's rules. Myth 3. I'll just add my kid to the deed. That's usually a present gift, can trigger the 5-year look-back, and exposes your home to your child's creditors, lawsuits, and divorce. It can also reduce step-up in basis at death. Use beneficiary-style transfers that complete at death. Don't create present ownership without counsel. Myth 4. The home is safe forever because a spouse or disabled child exists. Those are deferrals, not pardons. Recovery is paused while the spouse is alive, or while the minor/disabled child status exists. When the status ends, recovery can resume if the home then falls into probate. Use the runway to record the right deed and clean up beneficiaries now. Myth 5. Revocable living trusts block MERP. Revocable trusts are great for administration and avoiding multi-state probate. But in some expanded estate states, recovery can reach revocable trust assets. Confirm your state's definition of estate. If you need a shield and have time, consider a MERP. For late planning, use deed tools where legal. Myth 6. All life estates are the same. A traditional life estate often gives up control and can create a penalized gift if made inside the look-back. An enhanced life estate, Lady Bird deed, in states that recognize it, reserves full powers and typically avoids look-back issues because the transfer completes at death. Drafting precision matters. Myth 7. TOD deeds are automatic. Transfer on death deeds are powerful where authorized, but they're technical, exact statutory language, recording before death, and primary plus contingent beneficiaries. Miss one element and title can fall into probate. Confirm your state statute and county recording rules. Myth 8. Hardship is a sympathy letter. Hardship waivers are evidence-driven, deadline-bound, often 30 to 60 days, and defined by your state's manual. You'll need tax returns, pay stubs, bank statements, a household budget, valuation evidence, occupancy proof, and a clear tie to the rule. No math, no waiver. Myth 9. States always recover everything. Recovery is capped at the lesser of what Medicaid actually paid for covered services after age 55, or the net probate estate after allowed deductions. Mortgages, sale costs, funeral, administration, insurance, taxes, essential utilities, and necessary repairs can shrink the pot if you document them. Myth 10. The assessor's value is fine. Tax assessments often lag reality. Use a broker price opinion or appraisal pegged to date of death with photos and repair estimates where relevant. Accurate valuation and clean receipts reduce the net estate and therefore the recoverable amount. Myth 11. Liens are the main threat. For most age 55 plus long-term care cases, families never see a pre-death lien on a protected homestead. The hit is post-death as a probate claim. Focus on the path at death. Keep the home off the probate conveyor belt and build the deduction ledger. Myth 12. One small account won't matter. A stray checking account or vehicle in the decedent's name can force probate and open the door to recovery, even if the house was routed correctly. Add pod/TOD and contingents to every account and verify the institution recorded the update. Myth 13. DIY deeds are good enough. State-specific wording, reserved powers, and recording rules are non-negotiable. One wrong clause can convert an enhanced life estate into a traditional one or invalidate a TOD deed. Use local elder law counsel and underwriter-approved language. Myth 14. Selling solves everything. Deed tools protect the transfer at death, not sale proceeds during life. Sale proceeds are accountable for eligibility and can sink the plan. If downsizing is likely, map timing with counsel. Without a seasoned MERP, holding and transferring at death may be safer. Myth 15. We'll deal with paperwork later. Exemptions and hardship windows are short, Deductions require receipts, and valuation needs third-party support. Build the MERP binder. Now, deed valuation, expense ledger with exhibits, exemption proofs, and request the paid claims ledger early. Quick reality check. Plan the home's path outside probate, document exemptions with evidence, and keep a tight ledger. That's how you convert "we thought it was safe" into "claim closed." If you remember one thing, remember this: eligibility shields your home today, but probate decides tomorrow. So route the house outside probate, prove exemptions fast, and document every dollar that shrinks a claim. Here's your next step. Make a one-page asset path map tonight. Circle anything that still goes by will, and book a 20-minute call with a local elder law attorney to pick the right deed. Then add pod/TOD to every account and start your expense ledger. Want the advanced toolkit and real examples? Watch the video linked next and subscribe for state-aware, step-by-step guides. Checkpoint. Is your home's path still will probate? If yes, pause and fix it. Cliffhanger. One missing contingent beneficiary can reopen probate and revive recovery. Are your alternates listed everywhere? Humor beat. If your estate plan lives in a junk drawer, it's not a plan, it's archaeology. Aha. Path beats math. Route the house outside probate, and the recoverable pot often drops to zero. Motivation. Build the MERP binder now. Future you will high-five present you. FAQ lightning round. Fast clarifications. Can they take the house while I'm alive? If you plan now, you can keep it beyond reach later. Recovery generally happens after death, which is why the path you set today decides whether a claim can land tomorrow. Do wills avoid recovery? No, wills trigger probate. Lady Bird versus TOD? Both bypass probate where valid, state rules differ. Revocable trust safe. Not always in expanded estate states. 5-year look back. Gifts inside 60 months can trigger penalties. Caregiver child? Possible with strong proof care, delayed placement. Hardship? Deadline-driven evidence wins. Mortgage? Reduces net estate first. One small account can force probate. Add pod/TOD. Already got a letter? Calendar the deadline. Request itemized claims. Respond with exhibits. State differences. What changes and what doesn't. You've seen the playbook. Now let's localize it, because Medicaid estate recovery is federally required but state-run. The core doesn't change. States must seek recovery for long-term services and supports paid after age 55, plus related hospital and prescription drugs tied to that care. Recovery can't exceed what Medicaid actually paid, and it can't exceed what's legally reachable. Exemptions for a surviving spouse and a minor or blind/disabled child pause recovery. Hardship waivers exist everywhere, but you have to prove them on time. Those pillars don't move. What changes is the reach and the tools. First, the definition of estate. Many states are probate-only, meaning they recover from assets that pass through probate. In those states, routing the home outside probate with a properly drafted and recorded enhanced life estate, Lady Bird, deed or a transfer on death deed, often takes the house out of the recovery pot entirely. Other states use an expanded estate definition that can include certain non-probate transfers, like traditional life estates or assets in revocable living trusts. That's why you confirm whether your state is probate-only or expanded estate before you pick your strategy. Second, deed availability and mechanics. Some states recognize Lady Bird deeds. Others do not, but offer statutory transfer on death deeds. Each has specific language and recording rules. TOD deeds typically must be recorded before death and work best with alternates listed. Lady Bird deeds, where recognized, reserve full powers to sell, mortgage, or change beneficiaries during life, and generally avoid look-back issues because the transfer completes at death. Use the tool your state recognizes and the exact wording local title underwriters accept. Third, hardship and cost-effectiveness thresholds. Every state must offer an undue hardship process, but the criteria, forms, and deadlines vary. Many give 30 to 60 days from the notice date to apply, and some list small estate or low-value situations where recovery isn't pursued because collection costs exceed recovery. You won't know your options until you read your state's manual or have counsel pull the current guidance. Fourth, exemptions in practice. Federal deferrals for a spouse or a minor/disabled child apply everywhere, but proof requirements and timing differ. Caregiver child and sibling occupancy rules exist in multiple states, but the documentation bar is high. Physician letters, care logs, residency records, equity proof where required. Deadlines matter. Your quick localization checklist. Confirm your state's estate definition, probate-only versus expanded. Verify which deed tools are recognized, and the recording requirements. Pull the hardship criteria and timelines, and ask how the recovery unit wants paid claims ledgers requested and deductions documented. What never changes? Path beats math, deadlines are short, and clean documentation wins. Case studies. 3 real-world scenarios. Case 1, single homeowner proactive path. Maria, 72, owns a $420,000 homestead, no mortgage. Her state is probate only and recognizes ladybird deeds. With an elder law attorney, she records an enhanced life estate deed, reserving full powers, names 2 children plus alternates, and adds pod/TOD to every account. Years later, she receives Medicaid home and community-based services. The home stays exempt for eligibility. When she passes, the house transfers by operation of law outside probate. The state sends an intent to recover notice. There's no probate asset to reach. Claim closed. Same block, different outcome for a neighbor who relied on a will. The will forced probate. Recovery claimed the lesser of Medicaid paid or net estate, and the heir split what remained. Case 2, married couple using the deferral runway. James, 78, enters nursing care. Linda, 76, remains at home. Their probate-only state pauses recovery while a spouse is alive. During that deferral window, they record a ladybird deed. With alternates, sweep all accounts to pod/TOD and verify beneficiary confirmations in writing. 3 years later, Linda dies. The home passes outside probate. Non-probate accounts transfer directly. The recovery unit checks probate filings, finds no estate assets to reach, and closes the file. If they'd waited, Linda's will would have sent the house into probate, and recovery could have resumed against her estate. Case 3, caregiver child exemption. Proof makes or breaks it. Tanya moved in with her mom, Ruth, and provided daily care for 28 months that kept Ruth out of a facility. Their state recognizes the caregiver child exemption if care for at least 2 years delayed institutionalization. They built proof in real time. A physician letter stating home care delayed placement, detailed care logs with dates, hours, and tasks, W-2S and tax returns listing the address, and utility bills as residency evidence. After Ruth later qualified for Medicaid and then passed, the recovery letter arrived. They filed within the deadline, attached exhibits, and the state closed the claim under the caregiver child rule. Across town, a similar family submitted no logs and no physician letter, denied. 3 takeaways across all cases. First, in probate-only states, lawful probate avoidance for the home is often the cleanest shield. Get the deed right, list alternates, and record it. Second, spousal and disabled child protections are deferrals. Use the breathing room to reroute title and clean up beneficiaries now. Third, exemptions are real but evidence-driven. Physician letters, care logs, residency records, equity proof where required, and timely filing decide them. Paperwork and punctuality turn recovery into a winnable process. If you remember nothing else, remember this. Eligibility shields your home today, but probate decides tomorrow. So your job is simple. Pick a non-probate path for the house. Prove any exemptions fast. and keep a clean ledger that shrinks the number the state can reach. Here's the mental model that makes this stick. See Pillar 8 for the core principle. When the home never touches probate via a correctly drafted and recorded enhanced life estate, Lady Bird, deed where recognized, or a statutory transfer on death deed. With alternates, the recovery claim usually has nowhere to land. If your state uses an expanded estate definition, confirm the reach first. Then pick the tool that fits. Trust planning early, deed tools late, always with local language title underwriters accept. Second, deferrals aren't pardons. A surviving spouse or a minor/disabled child pauses recovery, but the moment that status ends and the home hits probate, the claim can return. Use that runway now to reroute title sweep accounts to pod/TOD and make sure contingents are listed everywhere, so one predeceased beneficiary doesn't bounce assets back into court. Third, paperwork wins. Build the MERP binder before a letter arrives. Current deed, date of death valuation, funeral and administration receipts, insurance, taxes, essential utilities, and necessary repairs, tied to a simple ledger with exhibit numbers. For caregiver, child, or sibling occupancy exemptions, evidence is everything. Physician letters, care logs, residency proof, and equity records where required. Hardship isn't a plea, it's math on a deadline. Finally, timing and precision matter. DIY deeds and December moves are how good families lose good houses. Get the deed drafted with state-specific language. Record TODs before death. Avoid look-back gifts. If sale is likely, map it with counsel, so you don't convert protected equity into countable cash at the worst moment. One page to act on tonight. Make an asset path map. Circle anything that still travels by will, and book a short call with a local elder law attorney to pick the right deed. Then add pod/TOD to every account and start your expense ledger. Path, paperwork, and punctuality. That trio turns, we hope, into claim closed.